Good morning, Ms. Bam.
Good morning, Chair. Good morning to the commissioners.
How are you this morning?
I'm
Nervous? So,
Chair, yes.
Well, just relax.
I will try.
These commissioners won't do anything bad to you. They are happy that you have made yourself available. They'll ask you questions. Maybe some questions might be difficult, but they won't be meaning anything bad.
Okay, Chair.
Okay.
Thank you.
Okay. Welcome to this session, and thank you for making yourself available for this interview and for consideration for appointment as a judge of the Gauteng Division of the High Court. I see that you hold a BProc degree, which you got in 1994 from the University of Walter Sisulu, is that right?
Yes, Chair. It was still called UNITRA then.
Yes. And you also hold an LLB degree from the same university where I got my LLB, but you got yours in 1996, University of KwaZulu-Natal.
Yes, Chair.
And you have got an LLM in tax law, which you obtained in 2003.
Yes, Chair.
You have also a postgraduate diploma in financial planning law, which you got from, is that the University of Free State?
Yes, Chair.
In 2007.
Yes, Chair.
And you have got an MBA, which you got from VETS in 2012.
Yes, Chair. That's correct.
You are passionate about education. Is that right?
That's correct, Chair.
Yes. Now, were you admitted as an attorney or advocate?
I was admitted as an attorney, Chair, in 1998.
Yes. And did you practice as an attorney?
I did very briefly, Chair, until 2001.
Yes. And then what happened in 2001?
I went to join an insurance company.
Yes.
Yes,
Continue.
Where I went to join Old Mutual Personal Financial Advice, a division of Old Mutual, where I was a legal advisor. And then in 2003, I went to join the Liberty Group, where I was a regional legal advisor, where I did pretty much the same kind of work.
Yes.
And later on, in 2003, at the end, I went to join an establishment, a brand new entity known as the Ombudsman for Financial Services Providers.
Yes.
Where I was appointed Assistant Ombud. And the function really was to resolve complaints from members of the public against financial services providers.
Yes. Was your private practice, limited to the years 1990, did you say 1998 to 2000?
2001, yes, yes.
Yes. You never went back to practice after that?
I never did, Chair, up until in 2018, where I went to consult with a local practice in Johannesburg.
Yes. Did that, I'm sorry, did that allow you to appear in courts?
Well, I did appear in court, Chair, initially during my articles and my reign as a professional assistant. During the period I was a professional assistant after admission, and thereafter never did. Yes.
And then in 2018, when you were a consultant in a law firm, you did not appear in court?
No, Chair, I don't.
you were simply giving legal opinion within the firm?
Yes, Chair.
Was that because you didn't like the idea of appearing in court and doing trials and arguing matters, or what?
No, Chair. It wasn't the case at all. I didn't want to start something that I wouldn't finish. At that stage, I had set my mind into pursuing my practice. I had my own individual practice which dealt with financial literacy. So I thought that if I dabble on the side on a part-time basis and concentrate on my practice, it would work.
Have you had an opportunity to act in the High Court?
Yes, I have, Chair, since 2019, April.
Yes.
I think I've acted, I don't know whether I'm correct. I've acted for about 54 weeks. I might be wrong.
Is 54 weeks about a year? Yeah, that would be about a year.
Somewhere there, Chair? Yes.
So you were acting for effectively 12 months?
Well, it wouldn't be a continuous period, Chair. I would be invited to come in, say for 6 weeks, which is what happened when I started.
Yes.
And then I was invited to come in for a term in 2019. And then in 2020, I did recess work. In 2020 still, I did just less than 6 weeks. I'm not sure if I'm correct. It was May 2018 to 18 May 2020 to 20th June 2020. And then I came in again at the end of the year and did a couple of weeks there. I came back in 2021 and I did the first and the second terms in full. I went back again towards the third term. I'm going back again. Well, I took oath of office yesterday, and I'll be doing some 2 weeks in Pretoria and another 2 weeks in Johannesburg.
During your acting stints, did you do motion court?
I did, Chair. Opposed and unopposed, I did.
Yes. How did you find that?
Well, I found the opposed one that comes with the assistance of council's heads and all of that, probably not as challenging, but the unopposed, where one is on their own and everything is left to them, I found it much more heavy because you do everything on your own.
Yeah.
Yes.
Yes. And did you do trials, civil trials as well?
I did, Chair. Civil, yes, I did. I did quite a bit of that.
And criminal trials?
I haven't done criminal trials, but I've done criminal appeals as a full bench.
Yes. Yes. When you appeared in court before 2001, or from 98 to 2001,
I did, Chair.
You did appear in and do trials.
I did do criminal trials and civil trials, yes, Chair.
Yes. You had finished your articles around what, 97?
1998 in September the 4th, I was admitted.
Yeah.
So I would have completed my articles somewhere there before that time.
Yeah. So the practice before you left practice at that time would have been for the balance of 1998 from September after you were admitted up to 2001.
Before I left to join the insurance environment, yes.
And did you leave around mid-2001 or towards the end of 2001 or early 2001?
I left in October
2001.
2001, Chair, yes.
Yes. You say you found that in regard to motion court, opposed motion you found it better to handle compared to unopposed because you have the assistance of counsel?
Well, Chair, it doesn't mean that I wouldn't be able to handle the unopposed.
You know, I
handled
accept
it.
that, yeah,
Yes.
I accept. But I'm saying when you look at the two, what you have told us is
Yes.
the opposed, it seems better for you to handle because of the assistance that you get from counsel with their written submissions, heads of argument, whereas with the unopposed, you might not have that assistance.
You're on your own, yes, Chair.
Yes. And in regard to opposed matters, motion matters, do you know the pluscon events rule?
Yes, I do, Chair.
Yes, just tell me what it is.
Well, thank you, Chair. The pluscon events rule says in opposed motions, because the premise is that you go that route where the facts are common cause and the issues are about the interpretation of the law, so the respondent's version will prevail unless it is so ridiculous that it can be dismissed offhand as not correct, as not true. That's the pluscon events. That's my understanding of the pluscon events rule.
Yes. And you said you have sat in criminal appeals.
I have, Chair.
Yes. And in civil appeals, have you sat?
I have, Chair, I have.
Yes. Are you familiar with the approach to be taken when you are asked on appeal to set aside or to reject factual findings that have been made by the court of first instance? When are you able to do that? When are you not able to do that? Are you familiar with that?
I am, Chair.
Yes.
Both where the facts do not support the ultimate decision, as evidenced from the record, do not support the findings that were made by the court of call, and where, in respect of the law, the court of call might have erred. I've handled both scenarios, Chair.
And if you are dealing with an appeal on sentence, do you understand what the approach is? When can you interfere with the sentence imposed by the lower court?
Yes, I am, Chair.
Yes.
So the Court of Appeal...
Tell us about it.
Thank you, Chair. So the Court of Appeal doesn't interfere with the sentence of the court of call because, in its view, it would have wanted to impose a different sentence. There must be certain bases for the Court of Appeal to interfere. One, the sentence is either shockingly inappropriate given the crimes and the circumstances that are prevailing in the case, or the sentence is shockingly lenient, for example, or trying to remember. Trying to think now. I've just done a criminal appeal now.
Okay. Well, if it comes back,
I'll think about it. Yes,
yeah.
Chair. Yes, but they're always in my mind.
Yes.
But there's a limited role to. There's a limited extent to which the Court of Appeal can interfere with a sentence.
Yes, the grounds are limited.
The grounds are limited.
Yes.
They would not just interfere because they think that the sentence is not the one they would have imposed.
Yes.
Yes.
Thank you. Judge President Lambo.
Thank you very much, Chief Justice. Good morning, Ms. Bam.
Good morning, JP.
Yeah. I'm happy the Acting Chief Justice took you through some of the legal principles, because at first blush, one would think you left practice a long time ago, therefore you've lost touch. with legal practice.
No.
And I think your answers tell me you haven't lost touch.
No, I haven't.
Yeah, so just dealing with a few issues. According to my count, you've done 8 weeks in unopposed, and you've done about 17 weeks in the civil trials, as well as 4 weeks in opposed motions. That's what your spreadsheet tells us.
I will accept that, JP.
Right. Now, what is it that you bring to the bench? In your own words, and please, I don't want a story.
Sorry, I didn't get the last
I
part.
said, I don't want a story. I just want you to tell us what you bring to the bench.
All right. I thank you, JP. I bring to the bench the sum total of my learnings and reflections as an ombudsman who had resolved complaints for plus minus 15 years. I bring the sum total of what I had learned in terms of dealing with people. I'll give an example of what types of complaints we would deal with at the Vice Ombudsman, which was a statutory entity and also a PFMA entity. I bring my experience in dealing with people. I'm used to producing a body of work, which is what we did. We crafted jurisprudence, which received the attention of the high courts and the appeals board, where a person affected by decisions of the ombud would want to query those. So those determinations that we produced often receive the attention of the High Court and the rulings of the appeals board, which is headed, by the way, by the retired chair of the retired justice of the Concord, Justice Mohoro. I bring, Chair, my experience in being able to run through with cases in a system of case management and adjudication. So case management is not something that's new to me. I'm used to setting predetermined objectives for an entity as part of a team, have those predetermined objectives examined by an external body and accounted for publicly. I'm used to producing decisions, which is the formal part of the work we used to do as an ombudsman, and have that publicly scrutinized and analyzed by people, and sometimes being criticized for it, where there's cause for that criticism. I am bringing to the bench all of that, but including what I learned in practice. I'm bringing to the bench the expertise that I possess in the space of financial regulation, financial services, and financial products, which, by the way, affect all of us without some of us being even aware. I don't know whether you would like me to give an example of the types of complaints we handled at the Vice Ombudsman. I would, if time permits.
I've got 2 more questions, Acting Chief Justice, to ask. One is, yes. So you bring financial services adjudicative experience to the bench?
Yes, JP.
Thank you. And that spans some 15 years, and that's part of the commercial workload of the division. Is that correct?
Yes, JP.
Thank you. My last question deals with your judgment spreadsheet. Tells me you've written judgments over a very wide spectrum.
Yes, JP.
What I want to know is, have any of those judgments been set aside? I mean, you say you started acting in 2019.
Yes, JP.
Have any of the judgments been reversed that you're aware of?
Thanks, JP. I do not have information about any of the judgments that I've written being set aside.
Yes.
I am aware of 2 judgments that were taken on appeal. I'm not sure what the outcome has been of that.
Yes.
I'm not aware that they've been determined already.
Sorry, Chair, one more question. That contempt of court issue with the Labour Court, I've tried to follow the documentation. What was the end total of it? Was the rule 9 side dismissed or what happened?
The rule was discharged, JP, because I provided an affidavit to court stating that I had never actually received the initial order, which in terms of the court directives was meant to be delivered to me personally.
Yes.
So I explained that to the court and the court was satisfied. So the rule was set aside.
Thank you. Thank you,
In
Acting Chief
November.
Justice. No further questions.
Thank you.
Thank you. Isile Sufi. Okay.
Thanks, Acting Chief Justice.
Okay.
I'm covered. I don't have a question. Thank you so much.
Thank you. Thank you. And then Commissioner Mpofu.
Thank you. Good morning, ma'am.
Good morning. Good morning, Commissioner.
How are you?
I'm well, thank you. How are you?
Okay. Thank you very much. No, I just wanted maybe to share with the commissioners my experience of your work. I had the privilege to do a lot, maybe, well, not a lot, maybe 5 or 6 cases for the Vice Ombudsman or person when you were there, without ever having met you. So sometimes they say your deeds precede you. So I can just share that my job as your counsel was to defend your judgments, so to speak.
Yes, Commissioner.
In the tribunal, which was then in those days chaired by Judge Harams.
He was actually Deputy Chair, Commissioner.
Oh, he was the deputy.
It's
okay.
always been chaired by
I
Commissioner
happened
Hall.
to appear before him all my matters. Yeah. But the point I really wanted to make is, as I said, to share with the commissioners that my task. I mean, we literally were successful in all those matters, simply because it was easier to defend those decisions, even though they were under serious attack from many lawyers, because of the quality of the decisions, more than the quality of the counsel. So, so now what I really want is maybe to follow up on the JP, because I think that's a very important process, skill that you would be bringing into the bench. What lessons have you learned in terms of adjudication, the reasoning process, to make sure that it is as rigorous as possible, particularly because in an administrative capacity such as the one that you held, every decision you made invariably would be reviewed by somebody, and some of the so-called big guns in the insurance industry. How did that assist you in ensuring that your decisions would be dispensable against such attacks?
Thank you, Commissioner. The first thing for me was in the adjudicative process, is to ensure that all the relevant information is contained in the file that's before you. The second thing would be to get a good grip of the case, of the facts of the case, and thereafter embark on research on the relevant issues that are presented in the case, apply the law as best as one can to the circumstances of the case, and having regard to decisions of superior courts where that's relevant, and the Constitution, obviously, and then reach a decision. That's the process that we followed.
Thank you. If I may sneak one in, DCJ, to say also in terms of transformation, What motivated you to entrust your work to black practitioners in the main? Because this was seen as so-called commercial work where black practitioners are not supposed to even venture.
It was a deliberate, first the conviction was simply that there's no basis that other practitioners or black practitioners couldn't handle the work. And we were confident enough to go forward with the proposition to our governance structures to say, we've got these truckloads of complaints. We see an opportunity to bring into the fold small firms and counsel from previously disadvantaged backgrounds. We want counsel helped by attorneys to provide opinions to the office. That's the only way we can get through the work. So the first thing is I didn't have the conviction that someone else can't do what I do as a black person. I just wouldn't understand the basis for that. And yeah, it just didn't make sense to me. But it had to be deliberate. Deliberate in the sense that you would not allow governance issues to frustrate the objective. Things like, oh, we spoke to firm A, they don't have a tax clearance certificate. Or we spoke to firm B, they don't. Why don't they have the tax clearance certificate? Bring them here, set a date, run a workshop, find out what it is that can be done, rectify what needs to be done. Once we get a tax clearance, we record the PIN and everything, because I regarded it as unprofessional to allow somebody to do the work. When they render the invoice, you then say there's a problem of a tax clearance certificate. Why allow the practitioner to do the work first? Get the governance issues behind you, then embark on the work and pay.
Thank you.
Thank you.
JSC.
Thank you,
I
Commissioner.
promise for taking 2 questions. I won't ask the next candidate.
Yeah, and that's on record. President Meyer.
Thank you very much, ACJ. Good afternoon. Oh, it's still before noon. Good morning, Ms. Pam.
Good morning, Commissioner.
I have to say this. I literally salivated when I read your CV, because the rare skills you possess are the very ones our courts so desperately need, and which black women very seldom have a chance to achieve. So what I want to ask you is, what is the secret? What has been the secret of success? What would you tell a young aspiring law practitioner, woman law practitioner, who is daunted by the prospect of delving into the commercial law world, because we have so few of that category of our society in this field? And secondly, the LSSA has highlighted this complaint that was brought against you by some faceless person or persons. Has there been any further progress with that matter? Those are my 2 questions, basically.
Thank you.
Thank you, Commissioner. I don't know if there is a secret more than hard work, determination, and the refusal to be held back from exploring things that you are interested in. And fortunately, if I might say, I was actually taught by Justice Meyer in my early years of studying the law, and it was rare those days to have women lecturers. I mean, the entire faculty was males, and we salivated, receiving a female lecturer, and we would harangue her and want to ask questions, and she wouldn't have time most of the time. So I think it's the determination, the hard work, and the refusal to be held back. and looking to those that have come before you, as they have set an example that encourages one to follow in these steps? That's the answer to the first question. The second question is, I don't have an answer to this complaint that was filed a couple of weeks before I ended my extended term at the Ombudsman. But I have tried to provide some information that gives a general idea of what would have brought vulnerability to the entity at that time. I tried to write to the public protector. Well, I did 3 times, cognizant that they don't exist to resolve one complaint. So over a period of 3 years, I've written thrice and I've never received a response. But there's something I would like to say about the complaint. And it really deals with the governance arrangements that were in place at the Fires Ombud at the time. Because the Fires Ombud is a public entity, highly regulated, and with all the necessary governance provisions for somebody who has a complaint against the Ombud. In the first instance, where you have a complaint against the Ombud, the HR policy, which was known to everybody, because one of our goals was to demystify the policies of the organization. So we would have the graduates and sometimes partnering with full-time staff members to disseminate information about our policies. So it was known by everybody that if you have a complaint against the Ombud, you send the complaint to the Ombud, and where the Ombud fails to resolve the complaint within a reasonable time, the next level of escalation is the board. And if you are disenchanted with the response to the board, there are various other angles. For example, our internal auditors and external auditors routinely called for information that could potentially derail the Fires Ombud in the pursuit of its goals. We had a fraud hotline where people could remain anonymous but provide critical information that demonstrate that, yes, somebody embarking on conduct that could undermine the entity from achieving its objectives. I include in the external auditors, the Auditor General's office. There was always an opportunity for people to submit that complaint, because routinely they would be calling for information from staff members, and even anonymously they could do that. There was always the chairperson of the audit committee. We had something called this climate survey, which tests the health aspects of the organization, where people could submit information anonymously to say, here's information that I think could undermine the entity, and this very head that's entrusted with this entity is actually the one perpetrating whatever information. They haven't done that. And as soon as we responded to the public protector, the office actually prepared the response, because everything that is in the Fires Ombud is not mine. It belongs to the public entity. So all that information was drawn from various archives and provided to the public protector. Never heard anything. Never got to see the actual complaint. Never heard who exactly was complaining. So I came to the conclusion that it is a scurrilous complaint. If the person had information about me that is calculated to cause any of the damage I was accused of doing, they would have long come forward. I haven't been the Fires Ombud for a number of years, and there's no reason why they wouldn't come forward. So the short answer is, I haven't heard anything.
Thank you.
Thank you, Commissioner.
Thank you. Ms. Bam, we want to make sure that you have had a chance to deal with each question put to you properly, but at the same time, we want to avoid long answers where you can avoid it. So I would appeal to you to restrain yourself, but at the same time, you must be able to deal with each question properly. So, but I just leave it to you for the time being to try and not give too long answers where you can avoid that.
Thank you, Chair.
Okay, all right. Commissioner Magwanisha.
Thank you, Acting Chief Justice. My question was covered by the President.
Oh, thank you very much. And then Commissioner Matolo Zepu.
So thank you, Chief Justice. Good morning, Ms. Bam.
Good morning, Commissioner.
And this side. Okay.
Oh, yes.
All right. I see your CV is very impressive. But one of the things I just wanted to hear from you, you left the practice quite early. You know? And I just wanted to see to know the reasons, you know, where you left early because you couldn't get work or it was a choice. That's just what, you know. Yeah.
Well, the first thing, Commissioner, is that I was employed by somebody. It wasn't my own practice. And at the point I completed my LLB studies, I had lost my last parent in the middle of the year in 1996. So what it meant was that a lot of my career choices would be sort of driven by answers, by opportunities that could give me an answer to support the people behind me. That's what happened, actually. So when the leader of the practice decided to leave his practice and go and join another entity, it was a little difficult for me because I was new, very green from university, to say I could soldier on my own. Maybe the fear was unfounded, but because I had this pressure behind me. Thank you, Chair.
Just a follow-up, Chief Justice. I see you've done Masters in Tax Law. As a consultant, have you done matters on tax? Because it's quite a rare, you know. I'm quite, I envy you. I would love to do tax law, but I'm old. But have you done cases now?
Thanks, Commissioner. Yes, I do cases in the tax court when I'm assigned to the tax court by the JP. I also do work that's got to do with tax matters with the firm that I consult to. Yes.
Well, I forgot earlier on to also say that I'm particularly impressed that you have done a master's in tax law, because tax law is one of those branches of our law where we don't have a lot of black practitioners and women being involved in practice, and we need a lot of black practitioners and women, as well as on the bench, black judges who would do tax matters, just as we need, you know, black judges and women who will deal with patent law and competition law and other branches of law that remain exclusively white or exclusively male or predominantly male. So I'm also quite impressed with that qualification, and I'm happy if the JP has already started, even when you are acting, putting you in tax law. Let's see some tax law reported judgments from black judges and women judges.
Thank you for the affirmation.
Yes.
Chair.
Thank you, Commissioner Tsepe.
Thank you, CJ. Good morning, Ms. Bam.
Good morning, Commissioner.
CJ, I almost said I'm covered, but
Which I would have loved.
I know, but I'm not going to. I was covered actually, but I would love to ask this of Ms. Bam. Ms. Bam, in your answer, you spoke about your case management capacity. What I wanted to ask you is, what do you think is the role of the High Court in advancing the right to access to justice? Access to courts.
Well, my answer is a very short one. It's a very important role. There's evidence of that already. For one, case lines, which was first introduced, as far as I know, in the Gauteng division, allows litigants unrepresented to log in within the privacy of their homes, and all that a presiding judge has to do is to explain the court processes to the unrepresented litigant, and a sound-minded person follows the proceedings, and you get to the end very quickly. I have not had any problems with unrepresented litigants, whether they approach the court and they're assisted there and they participate virtually. So my short answer is the High Court has got a very important role, and strides have been made. One such example is case lines. Thank you.
Thank you, Acting CJ. Thank you, Ms. Bam.
Thank you.
Thank you. Before I go to Commissioner JSC, may I check with commissioners who are virtual if there's anybody who has a question or question? Yeah, not questions, question.
Yes,
Yes.
thank you, CJ. I also noticed the JP's hand is up, and I'll defer to her out of respect for her seniority.
Yes, I'm sorry. Somebody was speaking to me. Please repeat what you said.
I gave way to the JP who's online, and then if I may ask my question as well.
Yes, okay. Leo JP.
Thank you, Acting Chief Justice, and good afternoon.
Good afternoon.
Oh, it's in the afternoon. Yes, thank you. Advocate Bam, I see on page 22 of CV, that is paragraph 5, or your application form, you stated that you have two reserved judgments. One was on the 7th of June, 2021, and the other one was reserved on the 11th of June, 2021. I hope they have been handed down, but I'm more concerned about this one on 2, where you say the plaintiff, or rather you reserve judgment, but now you did not continue the judgment because the plaintiff had not filed heads, and the reason being that counsel was indisposed. I just want to find out whether these judgments have been handed down, and number 2, whether after having reserved judgment on the 11th of June, this counsel did file heads, and when, or whether that judgment is still outstanding. Thank you.
Thank you, Commissioner. So the one case that was reserved on the 7th of June has been handed down. The second one, where the legal team of the plaintiff took ill, it wasn't just counsel, thereafter it was the instructing attorney. So the heads were eventually filed on the 30th or 31st of August. So that one is still outstanding because I was already in court and busy with matters in terms of the court role. But I've given an undertaking to... Shall I continue, Chair?
Yes.
I've given an undertaking to the parties that judgment will be ready by the 15th of October. And
Yes.
It's an undertaking I intend to meet.
Yes.
Thank you.
Okay.
Oh, sorry, the last part is that I don't have judgments reserved other than that judgment.
Yes.
Yes, thank you.
Yes, thank you, JP. The commissioner who spoke earlier on, who is
Yes, it was me, JDK.
Yes, okay.
Thank you,
Commissioner
SCJ.
Kane.
Yes, thank you very much.
Yes.
Firstly, good morning, and thank you for making yourself available. It is rare indeed to get women with your commercial qualifications and experience applying. I want to satisfy myself on one aspect, and just to show you this is not a catch you out type question. I just want to hear how you'd approach this problem. And it's because you come through this interview with quite limited court experience that I want to satisfy myself that if you were sitting in the tax court and you knew that there was a section of the Income Tax Act that applied to the problem that hadn't been pleaded in the parties' Rules 31 or 32 statements, how would you deal with a situation like that?
Thank you, Commissioner, and thank you for the information, first of all. There's enough decisions of superior courts that suggest that a particular section doesn't have to be pleaded for one to apply in resolving a dispute. So I would certainly consider the overall circumstances of the case and reach a conclusion. Thank you.
Thank you, Commissioner Kane. And now I'll go to Commissioner JSC.
Thank you, Chair. Ms. Bam, I think the DCJ has greeted you on my behalf. I wouldn't like to start it. The greetings by the DCJ extended to me. Don't take me as rude if I don't greet.
No, that's good. Yeah. But you remind me, Commissioner JSC, that commissioners are reminded that not to have questions is not a bad thing.
Yes. Mine is a follow-up question to your conversation with Commissioner Mpofu. Firstly, I must comment, I've been listening to many people. I think in this commission, you are the first person who would say you were troubled by the briefing of small firms. Briefing everybody interpret to mean briefing an advocate. So I must commend you for that. And secondly, I want you to comment on this. How do we ensure that corporate and big institutions such as the one that you are involved take seriously the issue of giving work to Black practitioners, in particular those small firms that are literally overlooked? And thirdly, which is something that even the government has now taken over, has just joined the crew, the governance issues that we're talking about. If you are doing work for government, the actual work is a minor, but the big work is when you want payment, you will be asked several documents and all those certificates. How can you just express onto that? Because I'm really interested to what you're saying. Is a breaker from the norm.
Thank you, Commissioner. I just want to check whether I understood the first question. How do we encourage other entities to take seriously Black practitioners? Well, I belonged at the time that I led the Faizenbud, I belonged to a cluster of, or a family of regulatory entities, and my understanding of the spirit in that circle was that the briefs are predominantly handled by Black firms mostly. I'm talking specifically about a sister entity to this is the entity that we led. That was a very obvious thing, that the most of the work goes to previously disadvantaged firms. Now, in terms of the second question of how does one get past the governance entities, I I don't think that there's a one-size-fits-all approach, but our approach was to advertise, first of all, and to call upon small and medium firms to come forward to participate in the work that we did, and they would then register their names, and there would come a time where the governance documents have to be inspected, and invariably 90% there would be something missing there. So my team, we had a like-minded approach to this thing. Was we do not remove somebody because something is missing. We then would arrange workshops to ask what exactly is wrong. Why can't you have a tax clearance certificate? And we also had the assistance of SARS, not because of close physical proximity, but because we made use of that line to say, please help us. There is this entity here. There are problems. Can you help us? And they would obviously assist us. So the important thing here is that we paid weekly. Every week there is payment that is going out. And for attorneys to remain as part of the project we did, it was a condition that they must pay counsel within a maximum of 10 days of monies showing in their account. Otherwise, they would be kicked out of the project.
Thank you very much. Thank you, CJ. In fact, Black people actually have themselves to blame, because in all these institutions, directors are Black people. They just stifle, oppress others. You are different. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner Njesi. Commissioner Schlemmer.
Thank you, CJ. Good afternoon, ma'am.
Good afternoon,
Can
Commissioner.
you share with us your judicial philosophy, please?
Well, Commissioner, thank you for the question. I'm not sure that I have a particular one, but I know that in discharging judicial work, I'm guided by the Constitution and the law. I don't think it would be appropriate of me to pigeonhole myself to a particular type of philosophy at this stage.
So you think it can change?
I didn't get the question.
Do you think your philosophy will change over time?
I'm not sure, but what I'm sure will not change is the guidance from the Constitution and the law and the decisions of the Superior Court.
Thank you very much.
You.
Thank you.
Thank you. Commissioner Shabangu Mdawi.
Thank you, ACJ. I think I've been covered by notice. I wanted to follow up on
Oh, thank you. Thank you very much. Commissioner Dodovu.
CJ, I'm also covered.
Yes.
But just between the two of us, I'm impressed with what I see. if I may just, just a question.
Are you going, is anybody going to change you from that view?
Nobody will change me. Nobody.
Okay.
Just one simple question from my side. Do you subscribe to a principle of expropriation of knowledge without compensation? Because what you have must be proliferated to others, must be planted so that they emulate your virtues and examples.
Thank you, Commissioner. May I answer, CJ?
Yes.
I certainly have to do that because it's been done for me by others who were before me. Thank you, Commissioner.
Thank you very much. I think we have come to the end of this interview. Thank you very much, Ms. Bam, once again for availing yourself. You are now excused.
Thank you, Chair. Thank you for the opportunity.